Good morning, everybody. Thank you for joining us today for Understanding Employee Benefits Law. Keep compliance every employer should know. We're glad you're here with us today. I am Jessica Cook. I'm the Compliance and Benefits Administrative Specialist here at Dominion Payroll, and we're thrilled to be joined by Brydon DeWitt, a nationally recognized employee benefits attorney at Williams Mullen. Brydon will walk us through key ACA compliance essentials, how to determine applicable large employer or ALE status, employer shared responsibility obligations, and best practices around cafeteria plans, pre-tax benefits, and required written plan documents. He'll also highlight common compliance pitfalls and practical steps employers can take to reduce risk. Before we get started, just a quick reminder, today's webinar is recorded and a copy of the recording and the slides will be sent following this session. We encourage you to submit any questions you may have throughout the presentation and we'll address them at the end. And with that, Brydon, I'll turn it over to you.
Okay, thank you, Jessica, and thank you everyone for joining, and thank you to Dominion Payroll for setting up this webinar. So this morning we're going to talk about some Affordable Care Act, just some basics on Affordable Care Act compliance, cafeteria plan compliance, and then something new, some new litigation surrounding voluntary benefits and ERISA fiduciary duty that I want to make sure that you are all aware of. The first two topics are really, this isn't breaking news or new law. The Affordable Care Act, believe it or not, was passed in 2010, signed into law by President Obama in 2010, which is 16 years ago. The Affordable Care Act could be getting a driver's license at this point. And the pay or play rules that are key for employer compliance were first went into effect in 2015. So the things I'm going to be discussing are not new, but I often encounter companies and clients that still don't quite understand the compliance complexities of the pay or play rules. And then the second topic, cafeteria plans, we're going to be discussing proposed regulations that were issued, I believe, in 2007. And these regulations are still in proposed form, but everyone, including the IRS, kind of treats them as final, as if they were final regulations. They're the rules that we follow until we, if ever, get final regulations from the IRS. And again, the third topic regarding voluntary benefits, there's some recent litigation, some complaints filed in December of 2025 that employers need to be aware of. So with that, let's move on to the Affordable Care Act. So we often refer to the employer mandate or the pay or play scheme under the Affordable Care Act. What we're talking about is the employer shared responsibility payment. And the idea is that applicable large employers have a choice. You can either offer affordable minimum value group health coverage to your full-time employees, to at least 95% of your full-time employees, or you can pay the employer shared responsibility payment into the system, and employees who go to the Obamacare exchanges, the healthcare marketplace, if they qualify, they receive a premium tax credit. They receive assistance for purchasing healthcare. Sometimes people say, well, is it legal for us to not offer health insurance? Yes, it's legal. It's not illegal to not provide affordable minimum value coverage, but what you're doing is you're choosing to pay into the system, pay the employer shared responsibility payment instead of providing your own health care for employees. So again, the ESRP is owed if an applicable large employer does not offer minimum essential coverage to at least 95% of its full-time employees, or if it does offer minimum essential coverage, but that coverage is inadequate under the ACA. Either it doesn't provide minimum value or is unaffordable. And then the ESRP is triggered only if a full-time employee receives coverage assistance, receives the premium tax credit through the ACA marketplace. So an employer could not offer, I'm not advising this, but an employer could not offer group health coverage to anyone, roll the dice that no employee would go to the exchange and qualify for the premium tax credit and would not owe the employer shared responsibility payment. So this so-called penalty or payment is only triggered if one of your full-time employees goes to the exchange and purchases coverage and qualifies for the premium tax credit. So let's kind of unpack these key concepts for the employer shared responsibility payment. We need to know who is an applicable large employer. Is your company an applicable large employer subject to this scheme? Who are full-time employees? What is minimum essential coverage? And is your coverage providing minimum value, and is it affordable? So an applicable large employer status is based on your workforce in the prior calendar year. So whether an employer is an applicable large employer in 2026 is based on the workforce in 2025. So the number of employees that you may employ today or that you hire this year has no bearing on an employer status under the subject to the ESRP in 2026. It will impact potentially 2027. So what you do is you look at the prior calendar year and determine the number of full-time employees employed each month. You also determine the number of full-time equivalent employees. And so that's, you add up the hours worked by all of your part-time employees and divide by 120. And so you add that number to your number of full-time employees. You add up all the months, you divide by 12 to get the average. And if your average is 50 or more, then for the prior year, then the employer is an applicable large employer for the current year. So if you did that math for 2025, then the employer would be an applicable large employer subject to the employer shared responsibility arrangement for 2026. There is, however, an exception for seasonal workers. So if, especially in the retail business, if the reason that the employer exceeds the 50 full-time employee average for the year is due to seasonal workers. So if your full-time employee number exceeds 50 for 120 days or less, and the employees in excess of 50 were seasonal workers, then the employer is not an applicable large employer. So if you're in the agricultural industry or you're in retail and staff up for the holiday season, that does not work against the employer as to whether they are an applicable large employer. And so here's an example of the seasonal worker exception. The employer has 40 full-time employees every month of the year, but they have 80 seasonal full-time employees September through December. So when you do the math, the average comes out to 66.5 full-time employees, and normally that would say that the employer is an applicable large employer subject to the employer shared responsibility payment. However, because the workforce exceeded 50 full-time employees for only 4 months, and that excess was due to seasonal workers, the employer is not an applicable large employer. So that's the seasonal worker exception for ALE status. This slide highlights a concept that many employers miss. So applicable large employer status is based on your control group or affiliated service group. So under Code Section 414 of the Internal Revenue Code, companies that are related through ownership. So you can have a parent subsidiary ownership group where a parent organization owns at least 80% of the equity of the voting stock of a subsidiary. Then those two employers are treated as a single employer for many purposes under the Internal Revenue Code, including the Affordable Care Act. Or you have what's called a brother-sister control group, where 5 or fewer persons, estates, or trusts have a controlling interest in collectively in the group of employers or group of companies. There are also affiliated service groups, and that's where you have service organizations that have related entities that either perform services with them to the public or that perform services to each other. They're called affiliated service groups. The rules are kind of complex, but you have to do this analysis. If you have related entities or if you're doing business with related entities, to determine whether a controlled group or an affiliated service group exists. So you could have one company that has 10 employees and another company that has 40 employees, and on their own, they would not think that they are subject to the Affordable Care Act employer shared responsibility payment requirement. But if those two companies are members of the same control group, they would meet the standard. So you count all of the employees in the entire control group. Some employers early on with the ACA tried to avoid having to comply by dividing up employees into different related entities. It didn't help because they were all in the same control group and treated as a single employer, or it's called an ALE group under the Affordable Care Act. So this is important. Some employers think they're not subject to the employer shared responsibility payment. They think they're not subject to the 1095C and 1094C reporting requirements, but they are because they are members of a control group or members of an affiliated service group. So that analysis is important, and that needs to be done. So who's a full-time employee? And here's the ACA. Nothing about the ACA is simple. This slide is solely for purposes of determining whether the employer is a applicable large employer. It's when you're counting up the number of full-time employees. And so for that purpose, an employee working an average of 30 hours per week is a full-time employee. Employees working 130 hours in a calendar month are deemed to be full-time employees. So those are the employees you count as full-time employees when you're doing the math to determine if you are an applicable large employer. Okay, so let's say you've done the math. You've determined that in the prior calendar year, the employer met the standard to be an applicable large employer. So now the employer, if it doesn't want to have to pay the employer shared responsibility payment, must offer minimum essential coverage that provides minimum value and that is affordable. Minimum essential coverage, pretty easy bar to meet. That's just basically employer provided coverage that meets the ACA reforms. If you're buying health insurance from a Anthem or a Cigna or United Healthcare, they will make sure that it meets the minimum essential coverage standards, and this coverage must be offered to dependents. Minimum value, almost all coverage that you would buy would probably meet minimum value, but the concept here is that the plan's share of total allowed costs of benefits provided under the plan must be at least 60% of those costs, and there is a minimum value calculator provided by the Department of Health and Human Services and by the IRS. So you can make sure that your plan is providing minimum value. What trips up employers isn't those first two prongs. It's that the coverage must be affordable. And so to be affordable, the amount that the employer charges the employee for coverage must not exceed the affordability percentage for the year of the employee's household income for the taxable year. So for 2026, the affordability percentage is 9.96% of household income. That number changes from year to year. So every year, every fall, the IRS will announce its cost of living adjustments, and there will be a new affordability percentage for the next tax year. But then you say, how do we determine household income? So you have your employee, and the employee has a spouse, and we don't know what he or she makes, and it's how do you figure out the household income? So the ACA regulations provide 3 safe harbors for determining household income. First is the federal poverty line. So the federal poverty line announced prior to the beginning of the taxable year, if you charge employees 9.96% or less of the federal poverty line for health coverage, then you know that you're providing affordable coverage. The second option is rate of pay. And so that's where you look at the employee's hourly rate of pay and determine whether the amount that you're charging for health insurance exceeds the affordability percentage of 9.96% of their rate of pay. And then the third safe harbor is W-2 compensation. The drawback with the W-2 safe harbor is you don't know for sure that you're meeting the affordability percentage until the end of the tax year, because it's based on the W-2 compensation for the entire year. But if you know what you're paying your employees and you know what their W-2 comp is, then you can set your group health plan insurance premiums based on that W-2 compensation. With the rate of pay safe harbor, you can figure out the different bands of pay for different groups of employees and charge them the appropriate premium based on the rate of pay. And you can set that up at the beginning of the year. So those are the three safe harbors that are permitted for determining whether the amount that the employer charges employees for coverage exceeds the affordability threshold. Okay, so what are we talking about? I said earlier, you have a choice. Okay, you can either offer affordable minimum value coverage or pay the employer shared responsibility payment. If an employer does not offer any group health plan to at least 95% of full-time employees, then it's the code section 4980HA payment, which is for 2026. This changes every year. $278 per month times the number of full-time employees in excess of 30. So that's if you do not offer coverage. And this is generally the more expensive penalty, because if you have 200 employees, then you're multiplying 170 times 278 per month that the employer is not offering any type of health insurance to 95% of its employees. If an employer offers some type of health insurance, even if it is unaffordable or doesn't meet minimum value, then we're under the second penalty here, the 4980HB penalty, where the employer is offering some type of health coverage. The penalty here is $417 but only per each full-time employee who actually goes to the exchange and qualifies for the premium tax credit. So you're not multiplying 417 times the workforce number minus 30. You're only paying the penalty for each employee who actually goes to the exchange and qualifies for the premium tax credit. So this is a strategy where employers, maybe they offer, we're going to talk about cafeteria plans. They offer cafeteria plans. Employee can purchase coverage pre-tax, and you think they're probably going to just enroll in our plan and not go to the exchange, then we're not going to have a risk of this penalty. Or you have a workforce where a lot of them have coverage through their spouses, or you think employees are not interested in enrolling in coverage, and now that the individual mandate under the ACA has been reduced to zero, they're not compelled by the Affordable Care Act to enroll in coverage. So some employers bank, they purchase a MEC plan, a minimum essential coverage plan, that does not meet the minimum value or affordability threshold, banking on only having to pay the $417.50 for each employee who actually goes to the exchange. So that's the choice the employer has. Purchase group health plan coverage that complies with the affordability minimum value requirements and offer it to employees, or kind of roll the dice with the employer shared responsibility payment. So the ESRP is based on the number of full-time employees. And so now let's forget what we talked about with determining whether the employer is an applicable large employer. And now we have to look at how the ACA determines who is a full-time employee to whom you have to offer coverage to avoid the employer shared responsibility payment. And the regulations provide two methods for doing this: the look-back measurement method and the monthly measurement method. The look-back measurement method is just that. It's a look-back test. So for employees who are not new hires, who have been employed on for more than a year, you look at the employees' hours they work during the look-back measurement period, and the employees who work 30 hours per week on average during the look-back period are then locked in as either full-time who must be offered coverage or part-time who do not have to be offered coverage for the going forward stability period. And every client that I have that uses this method does this on a plan year basis, on a 12-month basis. So if you have a January 1 plan year, in October, they run the test, they look back 12 months, and they determine which employees work 30 hours per week on average during that look back period. Those who did are then deemed to be full-time employees for the entire plan year, which begins January 1, and are offered coverage. Those who didn't meet the test are not full-time employees for the next plan year and do not have to be offered coverage, and there's no penalty for that. Even if they start working 80 hours a week in that next plan year, that doesn't change their status in that following plan year, but it could impact the math for the next plan year. So the nice thing about the look back measurement method is you have certainty. You can identify the population that has to be offered coverage prior to the beginning of the plan year, and you just move forward with that, and they're locked in with their status. For new employees under the look back measurement method, of course, they don't have hours. They don't have a prior 12 months or 3 months or 6 months to do the look back test. So if you hire a new employee and expect that employee to be full-time, to work 30 hours per week, they have to be offered coverage within 90 days. If they're hired as part-time or variable hour, we don't know how many hours they're going to work, then you can make them work up to 1 year and then measure their first 12 months of employment to determine whether they worked 30 hours per week on average. I'm going to move along a little bit because it's already 11:22 and I haven't gotten through my ACA slides. The monthly measurement period method is just month to month. If employees work 30 hours per week on average or during the month or 130 hours in the month, they are then full-time employees and you have to offer them coverage within 90 days. But you get that 90-day grace period only once per period of employment. So the issue with the monthly measurement method is each month you have to measure the hours worked and to determine who is in and who is out of the plan. And so that's why a lot of employers prefer the look back method to determine full-time employees. All right, so let's talk a little bit about cafeteria plans. Almost everyone knows that you can buy health insurance, dental, vision insurance on a pre-tax basis. And it's set up in payroll that employee contributions are pre-tax. And that's just done that way. That's what we know. Especially when I'm working on corporate transactions and doing diligence on a company, maybe my client is purchasing, often run into a situation where the company does not have a written cafeteria plan document. This is a key requirement for a cafeteria plan. So Section 125 of the Internal Revenue Code is the exclusive means by which an employer can offer pre-tax health and welfare benefits. In order to have a cafeteria plan under Section 125, you must have a written plan document that has been adopted before the beginning of the plan year. And the proposed regulations provide the content requirements. So you have to meet the requirements of the regulations in order to have a written cafeteria plan document. It has to be adopted. And there are also retroactive amendments to cafeteria plans are generally not permitted. We would need special guidance, like during the COVID, during some of the relief we had during the pandemic, some retroactive amendments were permitted, but that's only special cases where the IRS tells us we can do it. The general rule is no retroactive amendments. So if an employer doesn't have a cafeteria plan document, technically you can't fix it mid-year by retroactively adopting the plan, because the plan had to be adopted before the beginning of the plan year. So this is something that is often missed in compliance. Cafeteria plans restrict mid-year elections. So once an employee makes their election for the year, it is locked in for the entire 12-month plan year, unless you meet one of these exceptions under the regulations. So employees need to understand that their elections generally are irrevocable unless they have a change in circumstances. Often people often say change in family circumstances. They get married, they have a birth of a child, a dependent ages out of the plan, they move out of the service area. Unless you have one of those events, the election is locked in for the full 12-month plan year. And then finally, an area that employers often miss are the non-discrimination rules. So cafeteria plans are subject to non-discrimination requirements. First, the plan has to cover a non-discriminatory group of employees, and you borrow, if you have a 401k plan, it's the same coverage test that you have under Code Section 410B for a 401k plan or a qualified retirement plan. The group that's eligible to participate in the cafeteria plan must be non-discriminatory. And then among the participants in the plan, you have to meet non-discrimination requirements. You can't have overutilization of the plan by highly compensated individuals, or the plan is discriminatory. You can't have too much of the non-taxable benefits going to key employees. And so a plan needs to be tested throughout the plan year to make sure that you're meeting these non-discrimination requirements. A plan document, your cafeteria plan document, should authorize the plan administrator to change elections. I know the employee can't make mid-year election changes, but the plan sponsor, the plan administrator, can reduce a highly compensated employee's elections in order to allow the plan as a whole to pass the non-discrimination test. And another issue under cafeteria plans, the cafeteria plan is the mechanism by which you can offer a dependent care spending account. And so a dependent care spending account allows employees to put money pre-tax into an account to then pay for childcare. These plans are subject to the Code Section 129 non-discrimination rules for dependent care assistance programs. And the test that's often difficult for employers to pass is the 55% average benefits test. So the average dependent care assistance program benefits provided to non-highly compensated employees under the plan must be at least 55% of the average benefits provided to highly compensated employees. And what a lot of employers find is their highly compensated employees utilize the dependent care spending account more than the non-highly compensated employees, and they run into non-discrimination testing problems. Some of my clients have dropped dependent care assistance flexible spending accounts entirely because it was so difficult for them to pass this test. So employers need to be aware of this. All right, and then my favorite topic here coming at the end, voluntary benefits. So this is like your cancer, critical illness, hospital indemnity, employee pay all, after-tax benefits. And a lot of employers aren't paying attention to these because they don't really consider them part of their benefits. They might even consider them to be ERISA benefits. If you're taking employee money out of their paycheck and you have an ERISA plan that's funding an ERISA benefit, then those dollars are ERISA plan assets. The Department of Labor has an exception from ERISA for voluntary benefits if you meet these 4 requirements. The first 3 requirements here are pretty easy to know whether you're meeting those requirements to be exempt from ERISA. The 4th one here, though, is the problem, where we have endorsement. So if a reasonable employee would think that the after-tax voluntary benefits are a part of the employer's benefit program, then it's an ERISA benefit. So if you have these benefits listed in your benefits guide with your logo, company logo, if the company is providing any encouragement to employees to sign up for the AFLAC cancer insurance or expressing judgment as to it, then you are endorsing the benefit and it becomes an ERISA plan. If you have an ERISA plan, then you have fiduciary duty with respect to the assets. And in December, a law firm that led the wave of litigation in 401k and 403b fiduciary litigation has set its sights on voluntary benefits and filed 4 lawsuits against these companies on this screen, as well as brokers and employee benefits consulting firms. And basically the claims are that the employers, the plan fiduciaries, didn't pay attention to the fees and broker commissions with the voluntary benefits, and too high of a percentage of the employee after-tax contributions were being paid for commissions, right, instead of paying for benefits. And this litigation has just been filed. We'll see where it's headed, but it's important for employers to be aware of this and really build some of the infrastructure you may have around a 401k fiduciary compliance. Now start to look at health and welfare benefits and voluntary benefits in particular. And I knew I had a lot to get through. And here we are at the end, right at 11:30. And I guess I'll pass it back to Dominion Payroll, to Jessica.
Thank you so much, Brydon. Thank you, everybody, for joining us today and for taking the time to be a part of this conversation. We want to be mindful of everybody's time. We did receive a few questions, so we will connect with Brydon following this email and include a Q&A session in our follow-up email. We hope the session helped clarify key employee benefit compliance requirements and gave you actionable insights to better support your organization and reduce compliance risk moving forward. We appreciate your time and hope you have a great rest of your day. Thank you.